Well, I practiced for many years before the courts, and I always like to think that oral argument made a difference. And I may be more supportive of oral argument than some other judges. I think oral argument is extremely important, and my experience over 14 years at the court, I think, confirms it. Not because the advocates bring up ideas that the court hasn't thought about, or that are not present in the written argument, or are not reflected in the decisions of the court below. But advocacy in a court is really to persuade the judges about what the case is really about. And if, for example, a law dealing with child pornography, the lawyers for an accused, or who are against the breadth of the law, I mean, nobody is in favor of child pornography, so the question always is, where do you draw the line? And one set of advocates will say this law goes too far in interfering with freedom of expression and with artistic merit. You can criminalize half of the paintings in the Louvre if you take literally much of the law against child pornography. Well, if the court is persuaded that what the case before it is really about is artistic expression, then the court will incline to view with some limitation the law, the prohibition. On the other hand, the Crown and the people supporting that side of the argument will emphasize harm to children, will emphasize the role of pornography in grooming, in helping adults help pedophiles groom children in order to exploit them sexually. And if that is the way the argument goes, well, clearly the court is going to say, if that's the question, then we're going to apply this law with great vigor and force. So what's the role of oral advocacy? It's not to say to the judges, oh, well, you'd probably want to look at what Mr. Justice Smith said in 1970 in Australia on this point. That's not what advocacy is about. Advocacy is about persuading the court that what I say the case is about is what the case is about. And the reason I'm formulating the question as I am is that the answer will favor my client, whoever it is. In the Supreme Court, as soon as the oral argument is over, the judges withdraw to their conference room and discuss what the case is all about. So the last impression we have is not the written argument, it's not the judgments in the trial court or the Court of Appeal, it is the debate that's been going on in front of us for half a day or a day amongst the lawyers. And I have been present at so many cases where the judges in their early questioning seem to be drifting in one direction, only to have the court really reorient itself as a result of oral argument. I'll give an example. When I was before the court, there was a case involving whether the CBC could have cameras in the Nova Scotia legislature. And the CBC said this case was all about freedom of expression, and that electronic media uses electronic recordings, and therefore it was intolerable that they should not have their cameras in the legislative chamber. I was appearing for the parliamentarians, the Senate of Canada as it happened, and there were other legislatures represented. And we said that amongst the most ancient elements of our law was parliamentary privilege. Parliament has the right to exclude whoever it wants to exclude from the chamber when it's in session. And it has used that power since the 15th century. And that the privileges of Parliament are as much a part of the Constitution as freedom of expression. And you cannot use one part of the Constitution, i.e. freedom of expression in the Charter, to read out of existence another part of the Constitution, equally valid, equally entrenched, which in that case was the privilege of Parliament. So you could see the court almost in movement during the oral argument between an initial welcoming of the freedom of expression argument that, oh yes, we're in favor of freedom of expression, to recharacterizing the case, rethinking if really what the case was all about, and deciding that the privileges of Parliament institutionally was an extremely important public policy issue, and in the end the CBC was unsuccessful. Now I think based purely on the written materials, the CBC might have been successful, because that seemed to be the initial impression of the judges when they came in to start the hearing. So I don't think what is written down can ever substitute for a lawyer who is arguing, who is watching the 9 judges, who can assess the reaction of each of those 9 judges, can address concerns that seems to be bothering them, can respond to questions, can create a momentum in favor of the side the lawyer represents. And then when you combine that with a number of different lawyers representing different points of view, different clients, different organizations, then you have a real debate, and that permits the judges, I think, to have a very solid grasp by the end of it as to what is really important about the case.